Hello, how are you today? This is Bong Soo-jung, Korean Labor Attorney. Today I'd like to talk about what has been changed about labor law as of 2023. Labor law has been changed very much, but this year also we can see many changes. So today I like to talk about what has been changed. Also, I want to explain what are those changes. First one is the minimum wage. Minimum wage has been increased, but this year too there are no exceptions. So 5% increased compared to the last year's minimum wage. So the minimum wage is announced as of daily wage, hourly wage. So last year hourly minimum wage was 9,161. This year 9,621. So 5% increased for minimum wage. So then when employee worked 40 hours per week and they continue to work 1 month, they are entitled to 2,010,481. So that is a minimum wage for salaried workers. Our minimum wage applied to all the business or all kind of jobs. As long as they work, then they are applicable to minimum wage. Employees should pay the more than minimum wage, because the minimum wage is the minimum. So employer pay lower than minimum wage, then such a payment is invalid. Then company should pay additionally to meet some minimum requirement. Also, second item we have for change is the labor attorney. That is government appointed labor attorney. So that means government provide labor attorney service free of charge to those people who earn less than 3 million won per month. So it used to be 2.5 million won. Those employees who make such money, then they could receive some free labor attorney service. But starting January 2022, the service is expanded. So those employees who earn less than 3 million won per month, they are entitled to the free service from government for labor attorneys. So this is really good for the supporting those who earn a very low income. Also, third item we have, that is Labor Commission has a special function to kind of judgment function for unfair termination. Also special some remedy claim for unfair labor practice related to the labor union activities. Also they have some function for correcting some discrimination, illegal workers, they suffer some discrimination, and then they can have a remedy claim and they provide some judgment function for them. But this Labor Commission introduced more additional function, that is for gender discrimination or some sexual harassment case. Labor Commission includes 2 more the function to help those people related to such gender discrimination or some special remedy from the sexual harassment in the workplace. So I'm sure the Labor Commission will play a very important role. So Labor Commission has very strong advantage compared to the civil or administrative court, because there are several reasons. Labor Commission provide free service because there are no service fee for taking legal action. Also, it takes a shorter time compared to the other court case. Usually, an employee file the case, within 3 months they have to make a decision for such like discrimination or unfair like termination. Yeah. Also, those judges are very professional because they've been engaged in this kind of judgment for a long time. So, because they are specialized on only labor issue. Yeah. Also, the other one we have big change is Serious Accident Punishment Act. So, employer, even though they are not responsible for a certain job, a certain accident, they are responsible for severe punishment if they neglect to provide safety and health measure while they have some serious accident like a death of one person or like very serious the accident. Like someone, at least two employees should be treated in hospital more than 6 months. Then we call such a cases we call serious accident. Then if we employee neglect those safety and health measure and they have such an accident, then top manager like representative director, they are responsible for punishment. So the punishment is like imprisonment, not the shorter than 1 year, or some penalty within less than like 1 billion Korean won. So that means it is very severe punishment. So okay, this one, this Serious Accident Punishment Act is it has been implemented as of January 2022. So those employees that hired 50 workers, but 2 years later, starting January 2024, every company that hired 5 workers or more, they are applicable to the punishment. So employer should pay special attention to prepare some safety and health measure in their workplace. Also, the other changes is the company that hired more than 20 workers must prepare some recess area where employee can take a rest. So this is like every company that hire 20 workers must prepare some recess or some the rest place. So also those employers who have a certain job like special care service or some cleaning service or delivery service, in that such a company they hired, they have a workplace where there is 10 workers or more people working in that workplace. A company should provide a recess area so their workers can take a break there. Yeah. Also, final one is the overseas foreign workers. We call they have a H2 visa. So because of a shortage of labor force in Korea, government opened the eligible job. So until last year, they are allowed to work manufacturing or some construction or farming or fishing area. But now those overseas foreign workers, they are allowed to work almost every place, regardless. I mean, there are some exception, but the other one, they can work any place. That means they can work many service area. Yeah. Okay, these are recently changed the labor law. Okay, this is something you must be know. Okay, this is all. Thank you for watching. Bye bye.